Good afternoon, everybody. Our topic for today is crossover personal injury and workers' compensation, the remedy when someone else shares the blame for your work accident. So, what do you have to do when you get hurt on the job and there are other parties besides your employer that are responsible for your injury? Well, that is a crossover case. It means that someone or a third party other than your employer shared responsibility for your workplace accident. Why do we need to know about the crossover case? Well, for an obvious reason, to recover the maximum amount of damages we could get for our clients. In personal injury cases, our clients usually don't have money as the case drags to 1 or 2 years. As a firm, we're either finding funding for them or a Frahil law firm is funding them. But with workers' comp, while you litigate for PI case, our clients can get two-thirds of their income, up to a maximum of around $5,000 a month for 2 years under workers' comp, which is a no-fault system. The only thing you need to prove is that your client is injured on the job. For our current case, hired by a cleaning company, our client got to top of silo, slips off at about 50 feet, and sustained serious injuries. So that's how a silo looks like. So is this a crossover case? Yes, this is a crossover case where he can file a claim for employee workers' compensation against the employer silo cleaning company and personal injury claim against the owner of the silo under the liability premises and dangerous condition case. But before we go through the silo case, let us take a look at these relevant jury verdicts on accidents that happened while plaintiffs were on the job. Bartola Flores versus Anderson Hay and Grain Co. Incorporated, Armando Doe and Doe. The truck driver unloading hay falls off ladder as he climbs the top of load. The plaintiff had to go through surgeries on his knee and back. His knee and back injury caused him daily pain and made it harder for him to work and care for his daughter and caused him to change his lifestyle and gain weight. Plaintiff's contention. So what did this truck driver say? The defendant third party negligently failed to provide him a safety cage as required by his defendant's policies and gave him a 15-foot high extension ladder to unhook his load of hay on the top of his truck. Safety cages should be used when unloading trucks. Using ladders to unload hay was an unsafe practice. That was according to their expert witness. Now here's the defendant's contention. He said that plaintiff took it upon himself to wander around defendant's plant to retrieve the ladder and used it in violation of defendant's safety policies. What's the verdict? The jury awarded more damages than even was demanded of them in final argument to make sure plaintiff had enough money to compensate him for the rest of his life, considering inflationary measures and discount rates. Defendant agreed to pay the negotiated amount of $3,400,000 with a waiver of cost, interest, and appeal as a non-confidential settlement. Wow, good case. Here's the second case, Carlos Salazar versus Canon Constructors South Incorporated et al. In this case, a subcontractor falls into unprotected trench dug by another contractor. So there were two defendants, Canon Constructors, the general contractor, and Costco Fire Protection Incorporated. Plaintiff was at the construction site for his second day at work at defendant Canon Constructors when he fell into a trench dug by defendant Costco Fire Protection Incorporated. As a result of his fall, plaintiff suffered 3 left side rib fractures and ruptured spleen. Plaintiff spent 8 months healing at home, unable to work. Plaintiff eventually returned to work full-time, where he ultimately received a raise and promotion. However, he will suffer from rib pain for the rest of his life. Oh, that's a long time. So what were the allegations of the plaintiff? He said that both defendants were negligent for failing to ensure the trench was covered before plaintiff fell into the trench. Defendant Canon was the general contractor and had overall responsibility for safety on the job site. However, defendant Canon did not cover this trench even though there was testimony it had ensured other portions of the trench line were covered. Defendant Costco dug the trench but failed to ensure it was covered before going home the day before plaintiff fell in. As a result, plaintiff suffered severe and traumatic injuries. The damage to the plaintiff. Plaintiff suffered from broken ribs, ruptured spleen, ongoing nerve pain caused by intercostal neuritis. After plaintiff's ribs were cracked, the nerves running underneath these ribs were irritated by the breaks and were displaced inside the fracture lines, creating a condition called intercostal neuritis, which is permanent and will cause plaintiff lifelong pain. The verdict: the jury awarded the plaintiff a gross verdict or award amounting to $2,847,500. Award as to each defendant, so 70% liability on Canon Constructors and 30% on Costco Fire Protection. Now going back to the Silo case. Can our client claim employee workers' compensation against his employer Silo Cleaning Company? Yes. Workers' compensation is a form of insurance providing wage replacement and medical benefits to employees injured in the course of employment in exchange for a mandatory relinquishment of the employee's right to sue their employer for the tort of negligence. The trade-off between assured limited coverage and lack of recourse outside the worker compensation system is known as the compensation bargain. It ensures compensation for the workers. So what the client can recover under workers' compensation include medical treatment, lost wages, payments for time off work while you recover, a compensation payment for any permanent disability you incurred as a result of your injury, and job retraining if you're unable to return to your old job. But what about all other damages like for pain, mental anguish, everything else? So that's where personal injury comes in. So can our client file a claim? So again, can our client file a claim for personal injury? Yes, you must prove that the third party, the silo owner, is at fault. Personal injury cases are legal disputes that arise when one person suffers harm from an accident or injury and someone else might be legally responsible for that harm. It is clear that our client, Mr. X, can file a claim to the EWC. What we are trying to establish here is the liability of the silo owner for his personal injuries. That is to make a crossover. To establish premises liability, we must show that the following elements of premises liability are met. The silo owner had a duty of care. They breached the duty. The breach was the proximate cause of the accident and injury. The plaintiff suffered harm as a result. What we need proof to establish that the owner of the silo was negligent in ensuring that the silo is safe. The plaintiff followed the safety protocols to ensure his own safety while cleaning the silo. To the list. So, what to prove to win a personal injury claim against a silo? The owner of the silo where the injury occurred bear any fault for a dangerous condition that existed on that land or property. The condition either caused or contributed to the plaintiff's injuries. So you have to get a copy of the following: incident report given to the silo cleaning company, pictures of the accident scene, medical report, especially the report of the hospital where he was taken immediately after the accident, discovery questions to the plaintiff to serve as her guide in formulating a game plan, discovery questions to the defendant silo owner, copy of the silo owner's California Occupational Safety and Health Regulations, or Cal-OSHA permit. You have to hire an expert witness. If it employs fewer than 10 workers, so they are exempt from most federal health and safety rules. So we can hire an expert to inspect the place of accident, the silo, to check if it meets the general safety standards for silos. So here are some of the discovery questions I came up with. Were there warning signs around the silo that are easy to read, in good condition, and a list of hazards? Are there ladders up the side of the silo that should start at least 7 feet off the ground? Are ladders in good condition? Was it a permanent or portable ladders that the plaintiff used to get into the silo? Are the ladders enclosed with a safety cage? Did the plaintiff use fall protection systems when free climbing? Is there a certificate from the authorities that the silo is safe to enter and that the entry plan is acceptable? So in this case, because this is a crossover case, we have to retain competent workers' compensation counsel and to keep in touch with that attorney to best navigate through the workers' compensation system in the third-party case for the best benefit to our client. Because you also have to work on the EWC credit and EWC lien. Thank you very much for listening.